Yes.
Item number 41.
Yes.
For order, so it is required direction of state of order, my lord.
41.
40.
Yeah.
Last one.
It is just a typographical error, so it is to be correct.
I pray for the
That
return
should
of
be read as so and so per week, and it is to be order is to be upheld. That's all.
I pray for return of unnecessary, which is
You have to file an application for that. This has come for a particular purpose. Registry has pointed out that the order has been inadvertently typed as so and so. It is to be instead it is to be 24 to 2025. This much we will do today. If you want return of any document, please file an interim application. Okay. Yes.
Item 24, my lord, trace admission. It may kindly permit an adjournment for 1 week.
24.
24, my lord, trace admission.
For Mr. Patnaik.
Yes, sir.
You are the Central Government Council.
My lord, senior panel counsel.
Senior panel counsel. All right. Mr. Darpanarayan Patnaik, planning senior panel counsel. 6 for an adjournment. What time you say? It has no
1 week.
Achha, 1 week adjournment. Put a subscribe for a day limit. All right.
May I mention item 35 to be on my lord's board? My lords, somehow my name is not reflected. This was a matter which was disposed of by my lords. From the noting, it is showing that DRT had probably sought extension.
You got nothing to do. This is just to for extension. We had given a direction to the
Yes, my lords.
to dispose of the case within a particular
Yes,
time
my lords.
limit.
My lord,
Maybe that he requires some extension. So
the matter has been disposed of in the meantime.
it has been disposed of,
Yes,
but
sir.
there must be an order that you are to we direct the DRT cutter to dispose of the
Within 2
appeal
months.
within 3 months. Okay, so that within that period he has not, so he has sought
Yes,
for an extension. So nothing to it of extension कर दें तो उसे
yes,
कहते
my
period
lord.
देगी.
In the meantime, that has also been
All right.
obliged.
Yeah.
Supplemental list, item number 1.
Yes, my lord. Petitioner land and building has been acquired by the OP number 12, my lord.
Please be a little louder.
Here, the petitioner's land and building has been acquired by the opposite court number 12 and 4 collector.
Two means National Highways Authority.
National.
Yes.
There is the appeal provision, but here the petitioner, after receiving the determination amount, my lord, they did not considering the proper valuation and the measurement of the land.
So you are dissatisfied with the amount. So there is a provision that you are to approach the arbitrator.
Yes,
You are to approach so that it is to be referred to the 3G, I think 5 or something.
3G5. 3G5.
So why have you come here? Because he has to, on what basis you are seeking for enhancement. So those things are to be considered by the arbitrator in accordance with law.
Initially, some of the person has filed a writ application before the chapter.
There is a specific provision. Just a minute. If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the central government. And in that case, this Arbitration and Conciliation Act will be applicable, right? So you are to file this application under this particular provision and show that on what basis you are seeking for enhancement. Perhaps you have submitted some representation. Representation will not do. There is
with liberty.
definitely with liberty. The writ petition has been filed by the petitioner Kamalini Senapati with a prayer so and so that Land Council for the petitioner submitted that some representations in that respect have been filed before the collector, both opposite party number four. So let me opposite party number 4. Section 3G bracket 5 and 6 reads of National Highways Act 1956 bracket here after 1956 Act reads as follows. Quote for the data. In view of such provision, the Land and Council for the petitioner seeks permission to withdraw this writ petition to approach the appropriate authority for necessary relief. Accordingly, the writ petition is stopped. Next, also same. This full of commodity, same.
Third is also the same.
1, 2, 3, same.
Huh?
1, 2,
1, 2, 3.
one.
They were
No.
two
1,
7
2.
filed by the wife, and the
1,
third
2, 3.
one is by the husband.
1, 2, 3.
Both of them. Because 3 lands have been acquired.
What is your good name?
I'm Gautam Tripathi. G. Tripathi.
Gautam Tripathi, Land and Additional Government.
Opposite party number 1.
I am appearing for the Union of India.
अच्छा
Number 1.
ठीक है जी जहाँ ना रिफ्लेक्ट लिख दियो. You are appearing for whom and you are appearing the all right next
Same.
So 4.
4
Item 4.
Item number representation is very similar matter already discussed.
no representation कौन से देखा
Annex 5 is my representation.
wait what is your prayer in this
My fairly representation already discussed.
what is that representation
The representation is
The re-estimate.
John of Income eligible.
the compensation को ये receipts এটা খুব কি ডিল করছেন দেখি
John officer come
তো
eligible.
এটা you 2013 act তো
Again,
2013 act ର ଅଛି provision ଅଛି ଆପଣ ଯଦି accept କରିବେ ଯୋଉ compensation ଯଦି ଆପଣଙ୍କର କମ ହେଇଗଲା then you are to
We are accept this compensation amount and
No, there is a
my representation 26
provision
1
that
and
if you are
21.
dissatisfied section 16 na କେତେ ଗୋଟେ ଅଛି ପୁରା
64.
64
Yeah,
reference
Before reference case.
Huh.
My representation only for 26 1 and 26 B, 26 1A, 26A and 26 B.
To the zone officer.
John officer.
But you are also asking for the valuation.
Again,
Then
then
valuation means how the zone officer will determine the zone valuation.
John officer come LA collectors. Again,
Or he will fix the valuation.
right. Annexer 5.
any
Annexer
person interested was not accepted here by written application to the collector require that the matter may be referred by collector for the determination of the authority.
So in between, where is the provision for zone officer so that this application can be
to my Annexer 4.
annexed?
Annexer 4. Awarded notice.
All
Section
right.
32.
No, awarded notice ಎಲ್ಲ ಮತ್ತೆ receive କରି ସାରିଲେଣି.
Okay.
But if you want that in view of a benchmark valuation,
Okay.
the amount should be
Yes,
at a
no.
higher side. I mean, you are disputing
Yes.
that this is not the correct valuation.
Correct value.
So, ସେଠି
That
ଆପଣ
is only
ଏଠି ତ
64.
ଅଛି କହିଲା that the amount of compensation if somebody is not satisfied with it, then the written application is to be made to the collector so that it can be referred by the collector for the determination of the authority means it is the district judge.
Presiding officer, LAR and
हाँ ठीक
LAR
ठीक
and
ଅଛି
okay.
so for that a representation कौन करिवे ଆପଣ देबे ना ଆପଣ collector को application ଆପଣ grounds नेबे जे एई basis रे हमें जो एमाने जो determine କରିଛନ୍ତି that was not proper ତେଣୁ ଏଇ basis ରେ we are entitled to get more compensation.
Here the compensation has already been accepted.
Accepted.
Here it is
Accepted
not
with objections.
It's not.
Hmm.
It's not accepted. 64.
Again,
He has to lay his claim before the
a person
foreign.
not accepted.
Provided he has not accepted.
Again.
Here he has accepted.
Yes. Yeah, here he has already accepted.
Yes,
the compensation.
that is how 64.
64. Reference 64 item. 6.
But acceptance means यदि with a objection रे accept करथिबे ताहले भी केतोडा का decision अछि
Yes, that will come.
That
In
will
that
come.
case, under protest, suppose you have
हाँ
accepted.
under protest
He has to lay his claim before the collector.
collector हेले collector refer करिवे
Refer करिवे.
authority means the district judge principal district judge kind definition अछि ଅଥରିଟି ହଉଛନ୍ତି ଇଏ
Is the
ଏବଂ ଯଦି
appeal?
ସେ ଗୋଟେ ତାଙ୍କୁ ଟାଇମ ଲିମିଟ ମଧ୍ୟ ଦିଆହେଇଛି
Okay.
that within a period of 30 days from the date of application he has the reference ଯଦି ସିଏ ନ କଲେ
He can file it
ଇଏ
direct.
डायरेक्ट एप्लीकेशन करिवे अथॉरिटी को अथॉरिटी डायरेक्शन देवे कलेक्टर को टू रेफर द मैटर so that is very clear so in this case this representation will not do you have filed a representation नेले कोन आपण करिवे ए जो आपण देइचंती 17 18 रे आपण खाली लेखि देई चल जाइचंती
ଆଜ୍ଞା
you have to if this application would come along with the supporting document आपण तो ଗୋଟେ basis थिबो ना जे एई basis रे मु कहूची जे मु अधिका पाइबी तेणु से सब डॉक्यूमेंट्स से एप्लिकेशन सहित देबे एवं कलेक्टर रेफरेंस करिवो जदि न रेफर कला गोटे मास भितरे आपण डायरेक्ट अप्रोच करिवे कॉम्पिटेंट अथॉरिटी डायरेक्शन दबो कलेक्टर को रेफर करिया पे प्रोविजन इज वेरी क्लियर
collector refer this matter LR court in presiding officer and
एठी
LR
कर देइछंती
ଆଜ୍ଞା
तले कोन असुविधा हला पुनी
ଆଜ୍ଞା କହୁଛି ଆମେ compensation amount receive କରୁଛୁ ଯୋଉଟା as per benchmark
no no where have you stated that the collector has already referred where is that
collector not refer this matter we have filed a representation but the collector not decided our representation not refer this
then the provision is there
not taking any step
Unless you make a proper application under the relevant provision, why should the collector entertain it? What is the question of
ए
representation?
रिप्रेजेंटेशन एमती हबनी आज्ञा आपण 64 रे आपण को
आज्ञा,
प्रॉपर एप्लीकेशन
Go by the provision.
64 only 64 a person interested who has not accepted the award
you are perhaps not
we have received already award already received
yeah receive कले मध्ये जदी गोटे प्रोटेस्ट रे रिसीव करा दिबो
आज्ञा गोटे फॉर्म अछि सेइथरे we protect receive कला परे
एथि पई कोन
Exactly.
डिसीजन इंटरप्रेट हेछि जदी विथ प्रोटेस्ट आपण रिसीव करिसेंती
आज्ञा
ताहाले मध्ये ए प्रोविजन एप्लीकेबल हबो अर्थात आपण कलेक्टर को पाखरे प्रेयर करि परिबे जे रेफरेंस करंतु बेली मैटर टू द
Because your acceptance is conditional. That is how. So you make a proper application under the
Right.
provision.
लेखन
you will liberty for
Ah.
हां ये दैट इज लेखन द petitioners want so
6 is also the same.
6
File
4 and 6.
writ petition for a direction to the so and so है ना the learning counsel for the petitioner submits that in that connection a representation has been made by the petitioners under annexure 4 which is dated 39/2024 before the zone officer cum LA collector but the matter has not been referred to the authority however we find section 64 of the so and so act 2013 bracket hereafter so and so reads as follows section one ta khali kar debe one ro provision achi dita lekhibe ठीक है এবং নাই two টা भी লিখি দিও যে grounds মধ্যে ই করি admittedly the petitioner has not submitted any written application in terms of the provision under section 64 of the 2013 act land counsel for the petitioner seeks permission of this court to withdraw this writ petition to file appropriate application before the collector collector ki collector
Collector?
collector Morgan that is opposite party number 2 opposite party number 2
Zone officer or collector.
all right in view of the writ petition is disposed of
my humbly submissions lots of kindly deleted and withdraw as per my order in withdraw not entertain in withdraw colors and entertain koruna
ଆଉ କଣ କରିବୁ dismiss କରିଦେବୁ
liberty
And that is there. You said that it is to be approached under the provision. We have said.
yes petitioner is at liberty to
Yes.
all right so
6 is same.
5 4 and 6 they are same so disposed of yes
Item 5.
yes Mr. Purohit
The judgment of the Central Administrative Tribunal passing the impugned order of the petitioner dated 24/4/19 presently it being challenged.
impugned order is at page
Impugned order is at page 73.
76.
73 to 85.
73.
3.
No,
So 85 to 94.
85 to 90.
Well,
One applicant was Nakka Lakshminarayan Reddy,
well,
and these petitioners were the
the case
respondents.
arises out of a vigilance proceeding, CBI proceeding. CBI caught the petitioner red-handed in the office while accepting bribe of 5,000.
Right.
That led to CBI case and this case, departmental proceeding.
Yeah.
In the
What was the prayer before the
before the tribunal,
Central Administrative Tribunal?
when the
Was the setting aside the memorandum dated 24/4/2019?
that is for de novo inquiry. My OP1 had directed for de novo inquiry.
Okay.
The petitioner had directed de novo inquiry, which
Okay.
I required
Okay.
on the ground of delay only.
Okay. Then
There is absolutely no time frame for proceeding in a case. Moreover, when the police case is still pending, this case was
no, you come to paragraph number 8 of the impugned order.
implemented. The short point to be decided in this case is if the respondent number 2, that is Joint Chief Executive Officer, is competent enough to act as disciplinary authority and initiate de novo inquiry.
And secondly, delay in finalization.
Secondly, the delay in finalization of the earlier inquiry and initiation of de novo inquiry after the lapse of about 10 years will cause prejudice to the applicant. These two grounds. Out of the two grounds, on the second ground, the order will be passed.
Well, where is that relevant paragraph?
The passing of the
No, you upon question na second year quasi
para 13 my machine.
para 30.
Subtracting para 13 page 92. Subtracting this.
So after relying on the decision of the Honorable Supreme Court, which has been stated particularly in paragraph number 12. Paragraph number 12 will pardon, sir.
In the matter of state of AP versus N. Radhakrishnan, reported in 1998 4th SCC 154, the Supreme Court took the view that while examining the proceedings on the ground of delay, all the relevant factors should be taken into account, and disciplinary proceedings should be allowed to terminate after the delay, particularly when the delay is abnormal and there is no explanation for the delay. And the court has to consider the two diverse considerations, that is the prejudice caused to the charged officer due to the delay and the fact that normally disciplinary proceedings should be allowed to take their own course as per relevant rules. The Supreme Court in this context, in the matter of N. Radhakrishnan, held that it is not possible to lay down any predetermined principles applicable to all cases and in all situations where there is delay in concluding the disciplinary proceedings. Whether on that ground the disciplinary proceedings are to be terminated, each case has to be examined on the facts and circumstances in that case. The essence of the matter is that the court has to take into consideration all the relevant factors and to balance and weigh them to determine if it is in the interest of clean and honest administration that the disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for the delay. The WP number 15534 stroke 2015, delinquent employee has a right that disciplinary proceedings against him are concluded expeditiously and is not made to undergo mental agony and also monetary loss when these are unnecessarily prolonged without any fault on his part in delaying the proceedings. In considering whether the delay has vitiated the disciplinary proceedings, the court has to consider the nature of charge, its complexity, and on what account the delay has occurred. If the delay is unexplained, prejudice to the delinquent employee is writ large on the face of it. It could also be seen as to how much the disciplinary authority is serious in pursuing the charges against its employee. It is principle of administrative justice that an officer entrusted with a particular job has to perform his duties honestly, efficiently, and in accordance with the rules. If he deviates from this path, he is to suffer a penalty prescribed. Normally, disciplinary proceedings should be allowed to take their course as per relevant rules, but then delay defeats justice. Delay causes prejudice to the charged officer unless it can be shown that he is to blame for the delay and when there is proper explanation for the delay in conducting the disciplinary proceedings. Ultimately, the court is to balance these two diverse situations. Now, coming to explain the delay, my lord. May I take your lordship to the factual aspect, my lord?
No, you just come to
Continue.
paragraph 13 and 14. Read it out. Giving that.
Protracting disciplinary inquiry and keeping a government official under charges of corruption and disputed integrity cause unbearable mental agony and distress to the officer concerned, and for the mistake committed by the department in initiating the disciplinary proceedings. The employee concerned cannot be made to suffer. The Supreme Court in the matter of P.V. Mahadevan versus MD TN Housing Board, reported in 2005 6 SCC 636 said that under the circumstances of the opinion that allowing the respondent to proceed further with the WP number 15534 2015 departmental proceedings at this distance of time will be very prejudicial to the appellant. Keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the officer concerned. The protracted disciplinary inquiry against a government employee should therefore be avoided not only in the interest of the government employee but in public interest and also in the interest of inspiring confidence in the minds of the government. At this stage, it is necessary to draw the curtain and to put an end to the inquiry. The appellant had already suffered enough and more on account of the disciplinary proceedings. As a matter of fact, the mental agony and suffering of the appellant due to the protracted disciplinary proceedings would be much more than the punishment. For the mistakes committed by the department in the procedure for initiating the disciplinary proceedings, the appellant should not be made to suffer. The common thread running through the katana of cases is where charge is serious and provable by a large number of documents and witnesses. Reasonable delay in completion of inquiry is excusable, and time can be fixed to complete the same. While in cases of unexplained delay and charge is not serious, proceedings can be quashed. The court can entertain the petition and quash the proceedings where there is no satisfactory explanation for the inordinate delay in initiating and completing the departmental inquiry. In the present case, the inquiry was completed in the year 2015 after submission of reply by the applicant to the inquiry report. No reasonable and satisfactory reasons have been given by the respondents for the inordinate delay in completing the inquiry. Therefore, this tribunal finds that the initiation of de novo inquiry against the applicant would cause prejudice to the applicant and in violation of Articles 14, 16, and 21 of the Constitution of India. According to the impugned order dated 24/4/2019 is passed and set aside.
No, ଏଠି କଣ ହେଲା inquiry ଟା complete ହେଇଛି 2015 ରେ।
inquiry complete ହେଇଛି but inquiry କଣ ହେଇଛି ସେଟା ମୁଁ
ନାଇଁ ତାପରେ ଡିନୋଭୋ ପୁଣି କଣ ହେଲା ତାର ଏ କେସ୍ ରେ କଣ ହେଇଛି?
inquiry complete ହେଲା page 63 मैं भी सुनी।
କଣ ଗୋଟେ ଚାର୍ଟ କରିକି ଦେଲେନି?
Date chart ନାହିଁ। Date of events ଅଛି।
Date of events କେମିତି ଆରମ୍ଭ ହେଲା କଣ ହେଲା ତାପରେ ପୁଣି ଡିନୋଭୋ କେବେ ଷ୍ଟାର୍ଟ ହେଲା ଆପଣ ଯୋଉ
the report submitted by SP CBI regarding
ଦେଖନ୍ତୁ ଏଠି paragraph 2 ରେ ଲେଖା ହେଇଛି factual aspect ରେ 11/1/2010 ରେ ଜଣା ପଡୁଛି ଜଜମେଣ୍ଟ ର paragraph number 2 କୁ ପଳେଇ ଆସନ୍ତୁ। He was placed under orders of suspension on 11/1/2010. Right? So on the basis of so and so disciplinary procedure.
I am stating the factual aspect my lord in detail.
ସେଇଟା ଡେଟ୍ ଚାର୍ଟ ଟା କରିଥିଲେ ଭଲ ହେଇଥାନ୍ତା ନା ଆପଣ ସେଇଆ ତାପରେ ଆପଣ ପୁଣି ଗୋଟେ ଚାର୍ଜ ସିଟ୍ ଇସ୍ୟୁ ହେଲା 3/8/2010 ରେ
8/3/2010 department issued sanction for prosecution and ତାପରେ
ଲେଖା ହେଇଛି 3/8/10 paragraph 2 ଚାର୍ଜ ସିଟ୍ memorandum dated so and so ତାପରେ ଡିଫେନ୍ସ ସେ ଦେଲା 2012 ରେ
डिफेन्स 2 वर्ष ପରେ ହେଲା ସେ 2 ବର୍ଷ 2 ମାସ ପରେ
ଠିକ ଅଛି ହେଲା ଠିକ ଅଛି ଏଟା ଏ ପାର୍ଟ ଟା ତାର ଡିଲେ ତାପରେ appellant submitted the inquiry was done
3/14 ରେ copy of the inquiry report was forwarded to the charged employee for the reply.
Then ଆପଣ inquiry report
3/14
ରେ ଆସିଲା ତାପରେ form ହେଲା inform the appellant of the charge frame.
Charge frame was after 2 years again, after the so-called.
ଟିକେ ଦରକାର ଏଟା କେବେ କଣ ହେଲା ଟିକେ କନଫ୍ୟୁଜିଂ ଅଛି ସେଟା ହେଲେ
मेन थिंग कोन ପାଇଁ ଆମ ଏନକ୍ୱାରି ଏଟା ଅର୍ଡରଟା
ସେଇଟା ତ ସେଇଗୁଡାକ the principle which has been laid down by the Honorable Supreme Court in the aforesaid two decisions which are cited in the judgment.
Those are in respect of the cases wherein CBI angle was not there. In this case, CBI has caught him red-handed. Therefore, the disciplinary proceeding and a department and a
No, one
CBI
thing,
proceeding.
one thing you can say that, let us say that if we come to paragraph number 14 of this order, that where the charge is serious, let us say that this charge is very serious, corruption charge is there, and it is to be proved by large number of documents and witnesses, then a reasonable delay in completion of inquiry is excusable, right? And time can be fixed to complete the same. Kintu jodi charge ta serious nuhe, then and there is unexplained delay that can be caused. So distinctive feature hoଉଛି here. ତେଣୁ ଏଠି ଆପଣଙ୍କର ଡେଟ୍ ଚାର୍ଟଟା ଦେଲେ ଆମେ ଜଣା ପଡିଯିବ ଯେ ତାର ନେଗ୍ଲିଜେଣ୍ଟ କୋଉ ପାର୍ଟ, ଯେମିତି ଆପଣ କହୁଛନ୍ତି ଯେ ତା ଉପରେ ସର୍ଭ କରାଗଲା 2010 ରେ ସିଏ ତାର ରିଟିନ ଷ୍ଟେଟମେଣ୍ଟ 2012 ତାକୁ ଆଟ୍ରିବ୍ୟୁଟ କରିଦିଆଯିବ. So in that way you file a date chart, right? So can we bring it on Monday or so? We can bring it this matter, prepare a date chart, or you want more time? Put a date chart. Wednesday.
Yes. What is important for you to ensure, because the inquiry at the first spell has been completed within 1 year of submission of his reply. It was completed in 2013. He had replied in 2012. So within 1 year it has been completed. So the question is only with respect to the de novo inquiry. Why did you start it in 2019? So the time lag between 2014 to 19, that you have to explain.
The earlier incumbent in the post, he retired, and subsequently I came up. When I came up, I immediately took up the issue. Moreover, you
No,
worship
so that has to be seen.
explained. Okay, Lekondu. This writ petition has been filed by the petitioners challenging the order dated 11/8/2022 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 424 of 2019, in which the application filed, original application filed by the opposite party number 1, Naka Lakshminarayan Reddy, to quash/set aside the memorandum dated 24/4/2019 by annexure A/7 was allowed, and the order was set aside. After arguing for some time, Mr. Purohit, Land Council, appearing for the petitioner, seeks for an adjournment till next week to prepare a date chart. List this matter on, so it will come on 9th.
May I pray one thing? Let your lordship direct me to prepare a date chart so that it will be easier for me.
Acha, after we feel that a date chart is very much necessary. Stop. Land Council for the petitioner seeks for an adjournment till next week to prepare such date chart. Put up this matter on 9th April 20. Now you are satisfied?
Obligement.
Item 7.
May I please? In the land acquisition matter, my lord, my land has been acquired, compensation has been determined, my lord. My lord, there's in the meantime, all the recorded transaction has already died. They are between the interstate dispute between the parties. They have filed the objection case before the claim commission, my lord. In the annexure 2, my lord, the claim commission has decided relevant para is page 24, my lord. Since the issue involved in the
just a minute, just a minute. Yes, କୋଉଠୁ ପଢୁଛନ୍ତି?
Page 24, my lord. Order of the claim commission. Page 24, last para. Since the issue involved in the present case are very complicated, the grievance of the party cannot be adjudicated by the commission. Therefore, it is open to the party to approach the competent court. Therefore, we have approached the civil court. In the meantime, the ATM are trying to release the amount in favor of other parties.
No.
But
That is
where is that civil court?
Annexure 3, my lord.
That is filed in 2023.
My lord.
So what about this? Since civil case number 313 of 19 is disposed of, the interim order passed on 13/11/19. Miscase round 94/19 arising out of civil case stands vacated. It is in that case.
My lord.
Which civil case is referred to here?
Page 26, my lord.
Page 26.
In the court of senior division.
No, that you have filed into.
After the disposal of
that.
The claim commission, before the claim commission, you have approached the now the senior civil judge Sundargarh.
That is for partition.
It is pending, my lord.
So what is your grievance? Money is not to be disbursed.
In the meantime, ATM trying to release the amount in favor of other parties.
Tried means?
Notice.
Where is that? Where is the notice? How can we believe?
Annexure 4 ରେ ଗୋଟେ ଦେଇଛି ଯେ କମ୍ପ୍ଲିଟ କୋର୍ଟ ରୁ ଅର୍ଡର ନ ଆସିବା ପର୍ଯ୍ୟନ୍ତ ପଇସାଟା ରିଲିଜ ନ
କରନ୍ତୁ ଠିକ ଅଛି ଯେ କାହିଁ?
Where is that notice? And you could have also made a prayer before the
competent court to get the amount deposited in the court.
So ଆପଣଙ୍କର ଯେତେବେଳେ କେସଟା ଆଡଜୁଡିକେଟ ହେଇଛି ନୋଟିସ ନିଶ୍ଚୟ ଇସ୍ୟୁ ହେଇଥିବ ଡିପେଣ୍ଡେନ୍ସ ମାନଙ୍କ ପାଇଁ। So ଡିପେଣ୍ଡେନ୍ସ ମାନେ ଆପିୟର କଲେଣି ନା ନାହିଁ?
ଏତେଗୁଡା ପାର୍ଟି ତ
ଚାରିଟା ତ ପାର୍ଟି ଏତେ ଗୁଡାକ। There are 4 parties in the civil suit. So ଏତେ ଗୁଡା କଣ? ଯେମିତି କହୁଛନ୍ତି 25-30 ଜଣ ପାର୍ଟି।
Only 4 parties.
4 ଜଣ ପାର୍ଟି ସମସ୍ତଙ୍କ ଗାଁ ଏକା ଆଉ ଏତେ ପାର୍ଟି କଣ?
One address, everything is one.
No, you are not aware about the status of the civil suit. And you could have ଆପଣ ବର୍ତ୍ତମାନ ଯୋଉ ପ୍ରେୟାରଟି କହୁଛନ୍ତି ସେଇ ପ୍ରେୟାରଟା ଆପଣ ଯୋଉ not to disburse, can you not file any appropriate application before the said court?
Yes, you can very much file it and get an order to, at the worst, to get the file that the amount
to be deposited in
the court till it is decided.
Subject to the result of the civil suit. ଆପଣଙ୍କର partition ଇଏରେ decide ହେଇଯିବ କାହାର କେତେ ଭାଗ ସେ ଅନୁଯାୟୀ disbursement ହେଇଯିବ। compensation amount ଟା quantified ହେଇଯାଇଛି। deposit ହେଇଛି ଗୋଟେ authority। ଠିକ ଅଛି ଯଦି ଭାବୁଛନ୍ତି ଆମ ପାଖରେ ତ କିଛି ଡକ୍ୟୁମେଣ୍ଟ ନାହିଁ ଯଦି ସିଏ ଦବାକୁ ଚାହୁଁଛନ୍ତି କୌଣସି ପକ୍ଷକୁ ଆପଣଙ୍କର ଗ୍ରିଭାନ୍ସ ହଉଛି ସେଇଟା ତାହେଲେ you have to make an appropriate application that since this partition suit is pending and once it is disbursed then this it would be very difficult to get back the amount, so let it be deposited and
share wise apportionment.
But obviously that once this partition suit is filed means that was the purpose. So we are disposing of your file the appropriate application.
They may consider my application.
Consider
no.
Kiye consider? No. Look on this writ petition has been filed by Makardhoj Shamrat with a prayer for a direction to the ADM bracket R&R, MCL Sundargarh, opposite party number 3, not to release the compensation in respect of so and so till disposal of civil suit number so and so pending in the court of so and so or release in jahan likha hai. The Land Council placed the order dated 16/2/2022 under Annexure 2 of the claim commission, wherein it is observed that since the issues involved in the case are very complicated, the grievance of the parties cannot be adjudicated by the commission, and therefore it is open to the parties to approach the competent court over quorum for declaration regarding their entitlement to get the compensation against the acquisition of the aforesaid land project, on the basis of which compensation shall be disposed. The London Council for the petitioner submits that in terms of such order passed by the Claims Commission, the petitioner has already instituted civil suit number 40 of 2023 in the court of Senior Civil Judge Sundargarh, which is sub judice. Though it is argued by the London Council for the petitioner that notices have been issued to the parties for making disbursement of the amount by the opposite party number 3, but though no documentary proof has been placed before us in that regard. If the petitioner has any proof that such amount will be disbursed in favor of the opposite parties, number 4 to 7, during the pendency of the civil suit, which would be prejudicial to him, appropriate application can be filed before the court where the civil suit is pending. Therefore, we are of the view that this writ petition, the prayer in the writ petition, we cannot, in view of such one, so we are not inclined to entertain this writ petition. Liberty is granted to the petitioner to seek for appropriate remedy before the competent court disposed of. Yes.
Item 8.
Mention is made. What is your good name?
CHITTARANJAN Mishra.
ठीक है, नाम का लिखी दियो. Want show appearing for Shambhu Charan Nath Sharma, 6 for an adjournment for a week. Please this matter. And such answer. Yes.
Item 9.
Item number 9, Your Lordship. This is a writ application pursuant to orders of the Honorable Apex Court, challenging the order of the Claims Commission. Your Lordship has earlier passed orders issuing notice. May I just hand over a copy?
This is another application. Similar order has been passed.
Similar order, item number 9, 13, 17, 22, 26, 27, and 30. All are fresh matters. Yes, please.
ये similar matter है, ये already pass है इसी.
Well, let's see, Your Lordship will recall. I had myself moved these matters.
It is not functioning. The court has to consider the prayer in the petition.
Order.
Batch matter cycle.
Please.
Then go to copy.
Give a copy. I'll supply.
So এটা देखिन क्या correction prayer अछि कर देबे ना कर देगिन से issue notice होबो है ना how similar order pass करिवे.
Item number?
Your Lordship, item 9, 13, 17.
13.
Just a minute.
Yes.
13,
17.
17.
22.
22.
26.
26.
27 and 30.
27 and 30. लिखी था ठीक से. खाली I by N लिख दियो तो issue notice बोली बाकी से order टाउ देखी कर दे रहा हूँ. ये थोड़ा का correction करिए पड़ी होता है. Yes.
Item 10.
In this case, my lord, Mr. 1, notification was made for acquisition of the petitioner legal land, my lord, for construction of NH National Highway 55.
Yes,
And accordingly, my lord, competent land
So
acquisition of
you have received the compensation.
no, not received is objected, my lord.
Okay, 64 is applicable.
But before the concerned land acquisition officer, my lord, the complaint was made on annexure 2. Thereafter that were not considered, and that is
How
why
Tahsildar can consider it?
Tahsildar केमती करिवो अपन there is a specific provision परा section 64 रे
under
अछि
section 64 it is to be
आपण जदि गोटे अमाउंट जोटा की डिटरमिन करिसन दी अथॉरिटी जोटा की आपण कहउछंती at a lower side it should be enhanced. The provision is there and you are to file an application. It is to be referred to the competent authority. So
that application
ये
filed
बड़ा
on
order
annexure
follow
5.
हमें
ଏବେ 64 ରେ
हाँ एटा बोधे आइटम टा अछि बोधे आइटम नंबर 4 रे बोधे हम ऑर्डर करछु हला मनोज सेही टाइप रो ऑर्डर करिगिन ये कर देबे हला yes to file appropriate application under section 64 हला हां ताजेरे बोधे ताजेरे पिला जे सी has received the compensation
it is not accepted.
not accepted हला all right disclosure
Lordship, my lord, annexure 5, my lord,
our representation नु अपन को appropriate application दबा को पड़िबो ताजेरे अपन को को बेसिस रे आपण कहउचंती जे तांकर कैलकुलेशन टा भूल हेची आपण that has to be indicated with documentary proof है ना yes
specific date made.
आपण फाइल करिवे ना we are disposing of liberties granted to you to file the application now it is to हमें date कोन फिक्स अप करी
for disposal
ता देर प्रोविजन
No,
अछि
no. Disposal एठी हमें ଏବେ कहि परिबनी. You have not made an application, how can you ask for disposal?
आपणकर एप्लिकेशन देले केते दिन भीतर से रेफर करिवे सेटा भी अछि सी जदी न रेफर कले तापर भी कोन
Consequence
करिबा
कोन अछि?
हबो सब जिंस अछि ता देरे तेनु 64 अनुଯାयी आपन को एप्लिकेशन दबाउ पड़िबो एया ऑर्डर होछि डिस्पोजल
basis of enhancement time of the enhancement will
Yes.
have to be mentioned.
नेक्स्ट
Item 11,
Now, this is similar, but it's an applicant under section 28A. It's pending before the LAO. 28A LA.
Annexure to page 27.
ऑर्डर टू सिमिलर ऑर्डर फिल असिला
Annexure 3 tax. Annexure 3 on sir.
हां
Who could actually?
11, 12.
पेंशन को रिवीजन किया
Item number?
11, 12.
अच्छा से एप्लिकेशन करिवार गोटे डेट थाए 3 मास ना से पीरियड भीतर ही ठीक से
Otherwise, ultimately he will reject.
हां 3 months ना that is the
3 months,
period
3
3 months
So 11, 12.
11, 12,
एवडा
14,
एवडा सुसी करेक्शन कर दी जने नंबर भी दे दी जने so 11 disposed of 12 disposed of
14,
14 disposed of
15,
15 disposed of
16,
16 disposed of
18,
18 disposed of
19,
19 disposed of
21.
21 disposed of है ना सब गुड़ा का दे दी जने करेंगे ठीक नेक्स्ट
item 20,
यस बात हूँ
Now, here the grievance of the petitioner is that the under the land acquisition proceeding award was made and the money was given to the opposite party number 2 minor. But
No.
they have released the amount relating to the structure and the amount relating to the land have not been released in favor of the petitioner.
So for that, appropriate application is to be made if that has not been according to you properly calculated.
नहीं calculated ହେଇଛି ସବୁ ହେଇଛି
structure value टा calculation करना दी पर
ना structure value ଟା calculation କରି ମତେ ଦେଇ ଦେଇଛନ୍ତି
ଆଉ କଣ
land value जोटा award ହେଇଛି ସେଟା ତାଙ୍କ ପାଖରେ ରଖିଛନ୍ତି ଏ ପର୍ଯ୍ୟନ୍ତ ଦଉନାହାନ୍ତି
Oh, you want a disbursement? You want disbursement?
from the IDCO
IDCO.
ଆଜ୍ଞା
no where
the land belong to the IDCO
Right.
they have given under lease 99 years lease to me while I am continuing my
There was acquisition.
award was passed and differently for structure and also for the land.
Right.
Structure value was paid to me, but the land value has not been paid.
How can it be paid to you? You are only the lessee. They are the owner.
नहीं 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 अगर 99 years करके जो land रो value टा they have taken. Land रो value they have taken. IFCO has taken land value.
Correct. And that is what you want.
That well, the land after it is acquired.
You got the land on lease on
Again.
payment of premium.
Premium that is not land value.
Oh no.
Your lordship will kindly I have annexed. I have annexed.
Which one?
The lease agreement also I have annexed.
So you come to paragraph number 13 of your petition.
Yes.
Again.
Please come and face it.
Again. May I pray?
Please.
That it is understandable that since the opposite partner through ITCO at the time of execution of lease date has taken the entire land value and lease was granted for a period of 90 years. Hence, any amount awarded in respect of the land in question, the petitioner is entitled to get the same. In case they are not willing to give the cost of the land, they can also allot equal extent of land situated in the said area, and the vacant land is also available to be given in lieu of the acquired land in favor of the petitioner.
So how do you substantiate it? आपन को गोटे लीज रे गोटे लैंड टे देइतिले
Again.
तापरे आपन you have constructed something.
Again.
Structure value you have already received. Land value टा दे दीचंती जार से original land owner को दे दीचंती.
नहीं इटको को entire amount दे देले.
That is what. ITCO is the owner.
Structure और land value सब जगह दे देले.
Now
ITCO is released.
Structure value टा को आपन दे दीचंती. ठीक है. बाकी land value टा केमती आपन पाइबे सेटा होची तो question.
Because of the your lordship will kindly see, I have annexed in similar circumstances they are giving the land value.
Okay.
Your lordship will kindly turn to page 48.
Annexure?
That is annexure 9 million.
$40?
48.
That is a different letter with reference to
Same alert. The above it is
quantum of land. No.
When you receive the amount that structure value, which year?
17 million.
So by this they have referred to give
they
you
have given an alternative land.
Yes.
Alternative land.
That you can pray.
That is also I have.
Anyway, that you can pray. But you cannot have the right to have
and
the
2017 if you have got the value that the amount which you have for the structure. So why have you come to this court after?
No, I have repeatedly, my lord, you will also will kindly say they have received the representation of the petitioner, that is annexure. Every year, my lord, I have approached them.
So is it your first application or earlier you have filed application which has been disposed of?
Earlier I have also filed.
So
at that time, my lord, the compensation amount has not been paid. That I have also annexed that order.
No, this is the only petition, or after that you filed any application?
After that, no, before that, before filing of this writ petition.
Structure value आपण पाइला परे 2017 परे
ना that I have explained.
कारण ये रिप्रेजेंटेशन जो आपण देइछन सेटा होची 2019 मसिया
तापरे आजी
19 20 My lord, the opposite party number 2 to 5, my lord. Filed to opposite party number 2, my lord. Who is the managing director? IDCO. Aye. General manager जे आगे दिया है भी आपको दिया है your lordship will kindly see the representation managing director आगे देखो तो page 58 again
that after filing this representation
again
has not approved this book.
ना करनी हाँ
This petition has been filed by the petition. This is sugar engineer. That for direction to the opposite parties. For disbursement of the accounting system law. Was the value of the land favor of the petition, and if not, then not to be equal estimate for that. Industrial experience and 7,000 for the petition submitted. And by pointing out the representation dated 1/2019, the 15 series that land cost and compensation amount has been deposited by Dileo Punjab, Impoti, and Imbue has paid the compensation amount so far as structure of this transaction, the petition. But the land cost amount has not been refunded. Apatwa has made a specific submission this board that after filing the representation, the petitioner has not approved this board in any very specific that will be filed by the petitioner. So this matter on February
next week रहेगी aye
Item 23.
And then item 23, I'm appearing for the opposite party, my lord, today. And a copy may be solved on my.
Yes. We'll serve the copy, my lord. We'll serve the copy. We'll serve the.
associate by power for the opposite party. They both state on the submits that he has not received the copy of the
Kashyap, S.S. Kashyap, Satyachandra Kashyap. Senior Plan Council. Kashyap, Satyachandra Kashyap, Senior Plan Council.
Yes, yes. Available.
Okay, obliged. Obliged.
ତାର ଖାଲି ଗୋଟେ ସୂକ୍ଷ୍ମ ରିକ୍ୱେଷ୍ଟ ଆମ କୋର୍ଟର ଭଏସ ଟା ଆସୁନାହିଁ ପ୍ରପରଲି ସାଉଣ୍ଡ ଟା ଟିକେ ସେଠି ବୋଧେ କଣ ଆଡଜଷ୍ଟ
Wait, switched off. All right.
All right. Now you are able to hear.
yes now I am able.
So the date is fixed to Mr. Pari. Date is fixed to. अरे तमे कहुनो काहे की?
Yeah. It is
Sometimes during discussion we used to switch it off. So you have to point it out, sir. तो हमें मन भूली जाऊ छु ना तो है ना हाँ because the
Sorry, my lord, I have to
live stream तेणु है ना so it is to come on 15th April 2025. Yes.
Right.
Item 25.
Disposal of the unstruck who, my lord?
It rights to fair compensation.
कौन है जी?
Land acquisition matter, my lord.
कौन जी? कौन अनेक्स्ड टू टा कहू ना जी?
ଆମର କମ୍ପ୍ୟୁଟର ଏମଆର ପାଇଯାଇଛୁ କିନ୍ତୁ ତାଙ୍କର ଦେବଗଡ଼ ପୌରାଞ୍ଚଳ ମଧ୍ୟରେ ଥିବାରୁ ଅତି ନ୍ୟୁନ ଦର ଧାର୍ଯ୍ୟ କରି ଆମମାନଙ୍କୁ
So you are claiming for higher compensation.
yes ma'am,
Right.
In accordance with 13.
In accordance with 2013 Act.
yes ma'am.
So there is a provision, specific provision that if somebody is dissatisfied with the quantum of compensation, what he is required to do.
5G.
So you avail that provision.
And
This representation would not do the appropriate application showing the reasons why you are entitled to more compensation. That is to be filed before the collector and it is to be referred to the authority for determination, right? Under section 60. So it is all about a pass in item number
4
4 I would have କହିଥିଲି ତାଙ୍କୁ ସେଟା ଦେଖିଦେଇ କରିଦେବେ ହେଲା
yes
4 ହେଇଛି ନା
ହଁ ସେଟା 4
we are giving you liberty to file appropriate application before the authority ହେଲା disposal item number 4 का लिख दिया हां अब से आउ कौन सी ताकि प्रोजेक्ट ऑनलाइन नथिबो सेटा उठे चेंज कर दे हां हां
Item 28.
My lord, I am pleased to say, Lord, this is second round of litigation, my lord. In this writ application, the petitioner seeks for a direction to disburse the 1/3 share of the compensation amount to the petitioner awarded in LA case number 19 of 2018, my lord, pursuant to the judgment under Annexure 1, my lord. Now, what happened, my lord?
just a minute annexure 1 was your title appeal judgment
My lord.
which was disposed of on 17/2/2001
My lord.
तादर कौन आसिला कोड कले
Decided the 1/3 share, my lord. In hal hour, the petitioner has a name was not found.
तापर कौन हला
After that, land was
नहीं तो 2001 मसिया कथा तापर कौन कले आपण
तापर हम
नहीं जजमेंट पर कौन हला
अरे जजमेंट पर आपण क्लेम करी कोड करछंती ना नहीं ना कौन चुपचाप बसिगले हठात 24 वर्ष पर पळाइले
no.
How?
Thereafter, in 2018, my lord, land was acquired, my lord. When the petitioner no, my lord, he has filed an objection, my lord. But they have not disbursed a single amount. Thereafter, petitioner approached this honorable court, and this honorable court directed to dispose of the representation, my lord. In view of the direction of this honorable court, my lord, copy number 3, dispose of the representation
has been taken.
Annexure 4, my lord. Your lordship kindly page 58, my lord, findings, my lord. From the above discussion of facts and going through the WBC, it is found that the petitioner claimed the compensation amount proportionately as per the land acquired under Hal Khata number 270. No objection under so has been received from the petitioner Banawali Ransia. After payment of LA compensation of Khata number to awardee, the petitioner has requested to pay compensation money to him proportionately. On dated 14/3/2022, before payment of LA compensation to the other awardee of Halarar, Banwali Rakshan has given a written consent that he has no objection as per share was paid to the present artist, legal heir artist of Hal Khata number in view of it decided LA Commission of Land Acquisition for notified partner cannot be released in favor of Sri Banwali Ramsya, as his name is not found place in the ROR melody.
So, ଆପଣ ରିଟିନ୍ କନସେଣ୍ଟ ଦେଲେ
ରିଟିନ୍ କନସେଣ୍ଟ ତାଙ୍କ ପାଇଁ ମୋ ସେୟାରଟା ମୋତେ ସେମାନେ ବି ଅବଜେକ୍ସନ କରୁନାହାନ୍ତି.
where is that copy where you have given the written consent? ଆପଣ ପରା ଲେଖିଛନ୍ତି ଏଠି
ରିଟିନ୍
written
କନସେଣ୍ଟ
consent.
ସେୟାରଟା
Yes,
disburse
sir.
ପାଇଁ.
The written consent is that he has no objection
My lord.
if the LA compensation as per share
Share, my lord.
is paid to the present
My lord.
RTs, legal heirs of the RTs of so and so.
My lord, ତାଙ୍କ ସେୟାରଟା ମୋ ସେୟାରଟା ମୋତେ ଡିସବର୍ସ କରିବେ.
ଆପଣ କଣ ତା ଦେହରେ ଲେଖା ହେଇଛି ସେଟା ନ ଜଣା ପଡିଲେ କେମିତି?
ସିଏ ତ କହୁଛନ୍ତି
ଆପଣଙ୍କର ସେଟା କାହିଁ କନସେଣ୍ଟଟା
କନସେଣ୍ଟ ରେ କଣ ଦେଇଛନ୍ତି ଆଉ ସେଇଟା ତ କ୍ରକ୍ସ ଅଫ ଦି ମ୍ୟାଟର ଆଉ ଆଣନ୍ତୁ ଆପଣ ଯଦି କହିଛନ୍ତି ଆପଣ କନସେଣ୍ଟ ଦେଇନାହାନ୍ତି ଯେ
consent my lord, so far as for disbursement of they are share my lord, not
how
my
can
share.
we say without looking, because the order says that you have given it, how can you say?
ଆପଣ ଲେଖିଛନ୍ତି ଯେ କମ୍ପେନସେସନ ଦିଆ ହେଇଗଲେ ମୋର କିଛି
No,
ଆପତ୍ତି
no,
ନାହିଁ
ମାନେ ତାଙ୍କ ସେୟାରଟା ମୋ ସେୟାର
ଆଣିକି ପ୍ରଡ୍ୟୁସ କରନ୍ତୁ ଯେ ଆପଣ କହିଛନ୍ତି ନାଇଁ ମୋ ସେୟାର ଟା ମତେ ଦେଇ ଦିଅନ୍ତୁ ବାକି ତାଙ୍କ ସେୟାର ପାଇଁ ମୋର କିଛି ଆପତ୍ତି ନାହିଁ ଏମିତି ଆପଣ ଲେଖିକି ଦେଇଛନ୍ତି.
So you have ସେମାନେ ମୂର୍ଖ ହେଲେ ଯେ why did you come in writ when you are challenging the order of the authority in the writ? What is your challenge? That the authority did not act in accordance with law.
My lord.
Where is that? What is law? What is your consent? So without that, how can you expect us to pass an order? The basic document is your consent. Who is the authority ignored? That you must say.
Consent for a disbursement of their share.
You say, why should we believe you?
My lord.
You say whatever.
Unless we peruse the document, because the authority has perused that particular document, and on that basis he has said, if you say that this is an error of record, let us say you have not given any such consent, it has been wrongly recorded. So that particular document has to be produced before this court. This writ petition has been filed by the petitioner Panomari Naik alias Ranashia with following prayer for Roman 1 and Roman 2. Learned counsel for the petitioner submits that earlier the petitioner approached this court in WPC number so and so, and the same was disposed of by order dated 12/4/2024, in which direction was issued to the opposite party number 3, Special Land Acquisition and Rehabilitation Officer Moyurganj, to consider and dispose of the representation filed by the petitioner and pass appropriate order. Learned counsel for the petitioner submits that in terms of such order, a decision has been taken by the opposite party number 3 on 5th July 2024 under Annexure 4, which is impugned in this case. And he placed the findings of the opposite party number 3, wherein it is stated as follows. Quote paragraph number 4 of the finding at page number 58. The learned counsel for the petitioner submits that the petitioner has never given the written consent that the amount which is to be which falls in his share is to also to be paid to the artists of the legal heirs of the artists of Hal Khata number 217, and therefore the petitioner is entitled to get the compensation in view of the findings made in the judgment dated 17/2/2021 passed by the London prestigious Keonjhar in title appeal number 2 of 1995 to appreciate the submission raised by the London Council for the petitioner. The perusal of the written consent is very much necessary. Land Council for the petitioner seeks for an adjournment for kete din pond?
22.
For 2 weeks. Stop. List this matter on 22nd of April 2025.
Item 29.
29 may please match it.
Yes.
The order passed under Section 3B of the OGLS Act by the Additional Tahsildar Jatni on 27/7/2002, my lord, and the petitioner got to know about this in the year
After 22 years. The petitioner could know the order on after 22 years. And you have come in read now. After 22
It is an applicable order. I may permitted to file an appeal.
You can
It is
file
up
it.
to you.
Yeah, up
The
to you.
period has already elapsed.
3B is applicable.
Ah.
This is in respect of the OGLS Act.
Yes,
there is
yes.
some apply.
Section 7 is applicable.
Although there is a
देखी से ये
normal delay.
then a period specified ହେଇଛି କେତେ ଦିନ ଭିତରେ କରିବ ବହି ଆଣିଛନ୍ତି ବହି ବି ଆଣିନାହାନ୍ତି ସବୁ ତ ମୁହଁରେ ଅଛି ଆଉ କଣ କରିବା
3B and 7.
3B is applicable section.
7 is the provision for.
which OGLS ର 3B
3B order.
ठीक है
Redemption of land and imposition of penalty.
ठीक है 3B P capital B ना कौन
Yes.
Capital.
yes 3B ଟା ହେଲା resumption of land and imposition of penalty तापरे appeal provision ଟା काहे
Section 7.
7.
section 7 अच्छा 7A ना 7
Only 7.
7 is my
A is
lord.
revision.
section 7 appeal अच्छा and appeal shall lie against so and so
In 3B.
एरा 30 दिन मात्र अछि when such order is made by this one so is from the date of it has no appeal so unless it is preferred on the date of the order appeal so date of the order ଗଲାଣି ଏସବୁ
30 ଦିନଟା 30 ବର୍ଷ ହେଇଗଲା।
ତାପରେ ଗୋଟେ ଅବଶ୍ୟ ପ୍ରୋଭାଇଜ୍ ଅଛି ଯେ satisfy file an application ଲେଖନ୍ତୁ the petitioner Pramila Mahapatra has filed this writ petition challenging the order dated 27/2/2002 passed by Tahsildar Chutney in resumption case number 1734 of 2000. The London Council for the State has raised a preliminary objection that the impugned order is appealable. Moreover, the period prescribed for such appeal is already over. Be that as it may, since alternative remedy is available to the petitioner, we are not inclined to entertain this writ petition. Accordingly, writ petition stands dismissed.
नहीं मैडम एक्सटेंशन ऑफ टाइम petitioner in interim bail मैडम डेट ऑफ सरेंडर 8/4/2025 मैडम and file one extension of petition
सरेंडर कर जान सरेंडर କରନ୍ତୁ
only 28 दिन ପାଇଁ ଯାଇଥିଲୁ
सरेंडर କରନ୍ତୁ ତାପରେ ଦେଖିବା yes
10-12 दिन ଦରକାର
ଜମା ଜମା yes ହଁ ଡାକ
Supplemental list, item number 1.
May I please, your Lordship? Lordships, the present appeal has been preferred challenging the judgment dated 19/2/2025, in which the appellant has been convicted under section 302 of IPC and has been sentenced to undergo RI for life and to pay a fine of ₹20,000, your Lordship.
What is your good name and counsel?
Amlan Mahan.
Or Mr. Amlan Mahan. Admit, call for the trial court records, interim applications for bail and sterilization of fine to be considered after receipt of the trial court record. In the meantime, land counsel for the appellant shall supply the deposition copies of all the witnesses examined in the trial court to the land counsel for the state. Yes.
Item 2.
Obliged, Lordship. Conviction matter, man. Conviction for life under section 3025, right?
302.
My lord.
Same more. Yeah.
Item 3.
Conviction, your Lordship, under section 302 and 376 of IPC.
No. Mention is made. Please give your name. So submits on behalf of Mrs. Aditi Hota to adjourn this matter for 1 week. This matter in the commencing from 15th April 2025.
Obviously.
Yeah.
Item 4.
My lord, in this matter, my lord, prisoner's petition is there to conduct this case, my lord. That is
Very there.
What? My lord, a prisoner petition and bail.
Prisoner's petition
I have ascertained from the office, my lord, it is already in the criminal section, but it has not tagged, my lord.
No. Prisoner petition is with us.
ଆପଣଙ୍କର ନାଁ ନାହିଁ ପ୍ରିଜନର୍ସ ପିଟିସନ ଡେଟ୍ ହଉଛି ଏଟା ପୁରୁଣାଟା
That's what I mean.
କେବେ ଆସିଲା କହିପାରିବେ କି କେମିତି ଏଇ ବର୍ଷ ଆସିଛି ତ
ଏବେ ରିସେଣ୍ଟଲି ଆସିଛି ମୁଁ ବେଲ୍ ଆପ୍ଲିକେସନ ବି ଫାଇଲ ହେଇଛି IA 97/2025. My Vakladram is also there.
Because we have already appointed Mr. Mahapatra, I think, as the amicus curiae. But if prisoner's petition has been received, then it's okay. We'll see it. Mr. Mahapatra, we are calling for
I have no objection.
No, please. Ms. C. Kasturi, Land Council, submits that she has been informed that a prisoner's petition has been sent requesting for her engagement in this case to argue the criminal appeal on behalf of the appellant. And she has also filed wakalatnama
And also bail application.
and a bail application.
Hearing IA number 97/2020.
Which has been registered as IA number 97 of 2025. Let the registry verify the same and face the prisoner's petition, so also VNAMA and IA number so and so on record. Matter be listed in the week commencing from 15th April 2025. Yes. Mr. Ratikant Mahapatra and Council is present.
Item 5.
Item number 5. The petitioner will have doubled the interim bail granted by your lordship and surrendered in time.
So
Where is the certificate?
I have to file the certificate. Yesterday he surrendered.
All right, Mr. Vishwajit Nayak, Land Council submits that after availing the interim bail period as per order dated so and so, the appellant has surrendered yesterday and some time may be granted to produce the surrender certificate. Place this matter in the week commencing from 21st April 2025. In the meantime, Land Council for the appellant shall file the surrender certificate. Yes.
Item 6.
In item number 6, in say directed to furnish to the name and the RR to local security. That I have obtained.
Is an outsider or what?
Yes, an outsider.
Yeah,
so state has received instruction from so is mentioned that the address furnished by the appellant in the cause title is genuine. No criminal antecedent. Then you have filed the given the
yesterday I received one document.
No, we used to give two sureties. So please find another surety. We are just adjourning the matter. Okay. The Land Council, Mr. Nayak, appearing for the appellant, submits that he may be given some time to collect the documents of two local sureties and to hand over the same to the Land Council for the state for verification. How much time you want?
15 days.
2 weeks time for them. Matter will listed. We are placing it this matter on 29th. In the meantime, you give it. Place this matter in the week commencing from 29/4/2025. If in the meantime, Mr. Nayak hands over the documents of the two local sureties to the Land Council for the state, the same shall be authenticity of the documents and so on so shall be verified to the concerned IAC. Yes.
Item 7.
For 2 weeks after. You are Mr. Deepak Mishra. Land Council, Mr. Mishra, 6 for an adjournment of 2 weeks. Is this matter in the week commencing? Not sir. IA number so and so for bail. Let a copy of the interim application be served on the Land Council for the state. There 6 for an adjournment of 2 weeks. Matter be placed in the week commencing from 29th April 2025. Yes.
IA is there, my lord. Only deposition copy kara. IA is there. Deposition copy da.
Take care. कौन दरकार मैडम डिपोजिशन कॉपी दरकार आइएटा काटी दिए डिपोजिशन कॉपी yes
Item 8.
On Victor section 376. 3 madam.
we are appearing for the informant. Yes, madam. Yes. 2024 criminal appeal. So what is the conviction?
Life.
Life.
And offense is
376(3).
And POXO.
POXO is there also. So,
Offense was in 22.
33.
There is no external injury.
Interception was started after no external injury was seen. So on scene found that both the mounts and junction other death was due to asphyxia. Nature of death requires a specific opinion therein. It can be correlated to circumstantial evidence. So how the court found
Subsequent
that
lordship
it is a
kindly
case
see.
of
Subsequent lordship kindly see the next page, my.
paragraph
number
4 na 5
my.
5 पढ़ंतु.
On 16/1/2016, I received the requisition from the IIC Papada and the PS. The query was made regarding whether there was any sign and symptom hanging on the body of the deceased, whether the nature of asphyxia detected on the body of the deceased can be possible due to hanging, whether the tongue of the deceased was protruded, whether the viscera of the deceased may be sent for chemical examination. Our answers were there was no sign and symptom of hanging on the body of the deceased. The nature of asphyxia detected on the body can be possible due to hanging.
But there was no sign.
Then the tongue of the Swatantra, the viscera was reserved and handed over to police. Then the question
was not
as per our opinion, the death was asphyxia. Then a question was put to him by the court.
Please take your seat. Awesome.
Examination paragraph number 8, Lordship kindly see. What do you mean by saying our answers were there was no sign and symptom of hanging on the body of the deceased? The nature of asphyxia detected on the body can be possible due to hanging. The answer is we mean asphyxia detected on the body of the deceased may not be possible because of the absence of any kind of external injuries, and the asphyxia detected possible by smothering, strangulating neck, etc., or anything by
strangulating neck रे हेले भी injury थांदा.
और
अपन देखंदु जदि माने ये डॉक्यूमेंट हैंगिंग केस हबो, सुइसाइड केस हबो, लिगेचर मार्क रहबो. ताकू जदि प्रेस करिवे भी स्ट्रैंगुलेशन करिवे तो पैरेलल रहिबो लिगेचर मार्क. एटा रहले ओब्लिक रहिबो.
Only smothering may not.
स्मूदरिंग रे ये हबोनी एक्सटर्नल इंजुरी. तेणु से सेया ही डिस्टिंग्विश करूचंती जे जेहेतु बॉडी रो कोनोसी जगह रे ये नथिला, बट एटा जणा पड़छि से केस ऑफ एस्फिक्सिया, डेथ इज एस्फिक्सिया. तेणु से प्रथम रु किछ ओपिनियन देइ नथिले, कहितले जे एटा डिपेंड करिवो सर्कमस्टेंशियल एविडेंस.
नै होमिसाइडल दैछन
कोडी
ना ना
कोडी
कोडी
22 is the second doctor.
अच्छा
He is the first doctor and second doctor 22.
अच्छा ताले दैछन अछि त
PW 22 ना 20
22
ये भी ऑटोप्सी करथिले.
ये सेकंड डॉक्टर माने सब्सिक्वेंटली इट वाज रेफर्ड टू हिम. डॉक्टर प्रियरंजन ये ऑटोप्सी करथिले.
आज्ञा प्रियरंजन
असी कोन करथिले? फर्स्ट एड नहीं नहीं दी जण ऑटोप्सी करथिले. ऑटोप्सी रिपोर्ट केते होची एग्जिबिट 10.
हां ये तो कहउचंती डॉक्टर मनोज किशोर नायक PW
Manoj
33
Kishore Naik is the 33.
accompanied with me while conducting an autopsy.
ତାହେଲେ ଦି ଜଣ
ତାହେଲେ
କରିଥିଲେ
ଇଏ କଲେ he was accompanied. ଆଚ୍ଛା ତାହେଲେ ଇଏ କଣ କହିଲେ କୋଉଠି opinion is of both. But who has scribed it? PW 22. Acha.
Para 2.
Para 2.
This drug abandonment will now 43 years. The following injuries are there, both three longs are in that and blooding, fluid was present, stomach was empty.
ଗୋଟେ ଲାଇନଟା ଦେଖନ୍ତୁ ଏତିକି ଆଡୁ ଜଣ
Cause of death was due to asphyxia. Nature of death, my lord has already read it. Correlated to circumstances.
Asphyxia baby, account of
Where is it? Homicidal in nature. Then it is a conclusive one.
nature of death relating to the circumstances was homicidal.
कोठी कोठी
Next line.
next line.
अच्छा exhibit
Poisoning, garroting. The nature of death relating to the circumstances was homicidal. This is my report marked as exhibit 10. Where is my signature?
ठीक है ये बोले पॉजिटिव आसुन
Officer issued a requisition making query with reference to the postmortem examination report. On the same day, Dr. Manoj Kishore Naik received that requisition under his signature. This is the said requisition, such and such, wherein signature of Dr. Manoj Kishore Naik. In response to that requisition, Dr. Manoj Kishore Naik submitted a report stating that there was no sign and symptom of hanging on the body of the deceased. Nature of asphyxia dictated can be possible due to hanging, such as something. Then the last, Dr. Manoj Kishore Naik submitted a report with reference to the above query, and I also agreed with the said report. Dr. Manoj Kishore Naik opined that there was no internal injury found corresponding to the left ear which could have caused the death of the person. This is the said report. Such and such. Dr. Manoj Kishore Naik was the first medical officer. I am the second medical officer. While conducting the PM examination,
ये जदि एग्री कले केवल डॉक्टर मनोज कुमार नायक को रिपोर्ट को and Manoj Kumar Naik has been examined as PW 33. He has not specifically stated that the death is homicidal. ये बाबू केमती कहि देले एता exhibit 10 रे भी हमें देख सारलुनी which is exhibits रे किछि नाही homicidal विषय ते लेखा है सेया circumstance रो आपण देखिबे nature of death lekha hai to be correlated circumstantial evidence. And the query report is also marked as exhibit 11. प्रश्न जो गुड़ाक पचरा है तादेहरु दीटा 1 नंबर 2 नंबर पाइले से टेस्ट whether there is any sign and symptoms of hanging on the body of the deceased. Answer hochi there was no sign. Second question hochi whether the nature of asphyxia detected on the body can be possible due to hanging. Answer the nature of response can be possible by due to hanging.
Can be possible, whereas there is nothing, no symptom.
Whether the tongue of the deceased was protruded.
की पता data को confusion को.
तापर 4 ହେଲା viscera of the swans. तो कौन जाने तो किसी तो नहीं है इधर केमती कोई देबे. अच्छा
Type of what?
That I have submitted.
That has already been.
तो ये आपनकर दीटा डॉक्टर को ये पूरा कंफ्यूजिंग होची
No, 22 says, but basically the report is of Dr. Nayak, which he has accepted, agreed. So
आपनकर
Dr.
रिपोर्ट गुड़ाक मार्क ହେଇଛି ना एग्जिबिट 10 11 और 12 होची तार ओपिनियन ये तीनटा जाक रिपोर्ट रे कोनोसी जगह रे नाही जे
Homicidal
डायरेक्टली होमिसाइडल खाली
circumstances.
गोटे वर्ड लिखा ହେଇଛି जे टू बी कोरिलेटेड फ्रॉम द सर्कमस्टेंशियल एविडेंस डेड बॉडी
It's a para 5 रे PW 22 also in cross examination କହିଛନ୍ତି ଯେ Dr. Manoj Kumar Naik was the first medical officer and I was the second medical officer.
कौन पढ़ुछन से ये तो बारंबार हमें कहूछु yes, and he has agreed to the report of Dr. Naik, and what Dr. Naik has said about it.
Homicidal in nature, which has been we have suspected the crime of PMDM.
अरे जनक रिपोर्ट संगे से एग्री कले से लोकटा होचंती मनोज कुमार नायक निजे कहूनांती जे एटा गोटे होमिसाइडल डेथ अब ये जहां
Kimba exhibit, but where might have been examined later. But what about exhibit 10? That must speak about it. City kind. That is all right. But what about exhibit 10? Does it speak about homicidal? So mane कहले ना. I have received the PM report and you have opined the nature of death is to be correlated with circumstantial
डेड
evidence.
बॉडी केमिति हिसाब रे डिटेक्ट हला
Dead body, my the villagers found the dead body
कोड मिलला डेड बॉडी
from the home, from the home.
हाउस रे कोड मिलला केमिति अवस्था रे घर कबाट रो पोजीशन कोन थिला
Inquest कोन थिला?
So nothing has been discussed.
No. Inquest
मन
report
मन
थिबो ना.
आसीथिबे कि
Lordship kindly have plans to
ଭଡା
the
ଘର ପ୍ରାଙ୍ଗଣରେ ପଡି ଥିବା
ये प्रथमे देखिला डेड बॉडी टाकू
इनमेट्स तो थिले ना.
the husband was absent. Subsequently, it has been stated that the she ताको
मारिकी पळेला.
no.
What else? कौन?
Lordship kindly see during in phase 5 of the judgment during investigation police examined witness conducted there nowhere it has been stated how the dead body was recovered, who has seen the dead body first, even FIR मध्ये नाही. The sari was divided into two parts. One part was there on the bed and second part was.
So husband has not reported.
Husband has not reported.
PW 31 जो कहउचंदी 31 टा होची एडिशनल तहसीलदार
31 is the
31 होची additional तहसीलदार पापड़ाहांडी
inquest ପାଇଁ ସେଥିରେ।
inquest ରେ ସେ କହୁଛି ଯେ dead body of Namita was hanging from a wooden beam inside a house and the dead body was removed from the hanging position in presence of the police and witnesses, and thereafter the police officer on duty conducted inquest over the dead body in my presence and inquest report he kala tale dead body ro position eya thila.
And one of the uncle of the deceased, he has stated that the informant stated before his uncle that the Santosh discussed before me that his sister committed suicide at Villa Simla, witness number 25, your lordship kindness. He is the uncle of the deceased, before whom the informant has also stated that his
ମାନେ ଆପଣଙ୍କର plea କଣ 313 ରେ
330
ହଁ accused statement ରେ ଆପଣଙ୍କ plea କଣ ଆପଣ ସ୍ତ୍ରୀ ଆପଣଙ୍କ ଘରେ ଥିଲା ଆପଣଙ୍କ ଘରେ ତାର dead body
frequently quarrel between the husband and wife.
ମଲା କେମିତି ନା frequently quarrel
କଣ ବୋଲଛି?
She has committed suicide.
suicide ତ ହବନି ଏଇଟା ନାଇଁ ନାଇଁ suicide ତ ହବନି ଡକ୍ଟରଙ୍କ ରିପୋର୍ଟ ଅନୁଯାୟୀ
ଆତ୍ମହତ୍ୟା ତ
ଯଦି ଆତ୍ମହତ୍ୟା ଝୁଲି ଥିଲା ତାହେଲେ ଆସିଥାନ୍ତା ligature mark
One of the witness clearly stated that I found the ligature mark.
No, that is not all. No, the medical evidence should be
Evidence is not.
So medical evidence ରେ ଯଦି ନାହିଁ ଏବଂ ତହସିଲଦାର ନିଜେ ଦେଖୁଛନ୍ତି ଯାଇକିନି ଯେ ଯୋଉଟା ଝୁଲା ପୋଜିସନ ରେ ଅଛି ତା ମାନେ obviously ମରା ହେଲା ପରେ ତାକୁ ଝୁଲା ହେଇଛି ଯୋଉଥିପାଇଁ ତାର ligature mark ନାହିଁ ଅର୍ଥାତ the cause of death was not due to asphyxia due to hanging. So after his death the dead body was hanged from that position. So then the only other possibility is because it would have been a case of strangulation ne madhya ligature thanta ତେଣୁ ଜଣା ପଡୁଛି ସେ ଯୋଉ ଡକ୍ଟର ଯୋଉ କହୁଛନ୍ତି ସ୍ମୁଦରିଂ ହେଇ ଡେଥ୍ ହେଲା ପରେ ତାପରେ ଟଙ୍ଗା ହେଇଛି ସେଠି ତେଣୁ ଆପଣ ଏକ୍ସପ୍ଲେନ କରୁନାହାନ୍ତି କିଛି
That is not explained.
So
even the husband was not also present at the time of occurrence. He was the
एक केस रे ये जो आपण जो प्ली नौचंती सुइसाइड प्ली that would not be acceptable because of the evidence of the two doctors ଏବଂ ଡକ୍ଟର୍ସ କୁ ଆପଣ କିଛି ଆଣି ନାହାନ୍ତି ସେମିତି ଏବଂ ଡକ୍ଟର୍ସ ମାନଙ୍କର କ୍ଲିୟରଲି ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ଯେ ligature mark ନାହିଁ which a normal course ଯଦି ଏଇ ଟାଇପ ର ଝୁଲିବା ଅବସ୍ଥାରେ ମିଳିଥାନ୍ତା ତାହେଲେ ନିଶ୍ଚୟ ligature mark ଥାନ୍ତା
ligature mark would have been there. Tongue was not protruding.
Not only internal injury or outside injury also. Not only internal.
That is why it is only in smothering could be possible.
Smothering ରେ death ହେଲା ପରେ
ତକିଆ ଜାକି ଦେଲେ କେବଳ that is
even
possible.
ତକିଆ ଜାକି ଦେଲେ ବି some external injuries must
No,
be.
no.
ଗୋଡ ହାତ ଛାଟିବ କଣ?
ଆଚ୍ଛା କଥା ନ ଛାଟିଥିଲେ କଣ
ବେଡ୍ ଉପରେ ସ୍ମୁଦରିଂ କରିଦେବେ ତାହେଲେ
no prison
ତାପରେ ନେଇ ଟଙ୍ଗେଇ ଦେବେ and ଏଇ ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଯେ he was not found ସେ କଥା ତ କହିନାହାନ୍ତି ଆପଣ ଯେ ଆଜ୍ଞା ମୁଁ ଅନ୍ୟ ଜାଗାରେ ଥିଲି ମତେ କିଏ ଖବର ଦେଲା ତାପରେ ମୁଁ ଆସି ଦେଖିଲି
one witness stated that
no witness stated but what you said
two statement of one let me examine
accused statement କିଛି ନାହିଁ ଯେ
ମୁଁ ସେ
ଆପଣ ଘର ନଥିଲେ
ବରଂ ଆପଣ କହୁଛେ ମୁଁ କିଛି କହିବାର ନାହିଁ
because
no he has answered all the question differently
କାରଣ ଏ ଟାଇପ ର କେସ୍ ରେ ଆପଣଙ୍କର accused statement ର ମଧ୍ୟ ବହୁତ କିଛି ମାନେ ରହିଛି ରେଲେଭାନ୍ସି ରହିଛି ଇମ୍ପୋର୍ଟାନ୍ସ ରହିଛି ଆପଣଙ୍କର ସ୍ତ୍ରୀ ଆପଣଙ୍କର ଘରର ଗୋଟେ ରୁମ ଭିତରେ ତାକୁ ସେ ଡେଥ୍ ତାର ଡେଡ୍ ବଡି ମିଳୁଛି ହ୍ୟାଙ୍ଗିଂ ପୋଜିସନ ରେ which is not the cause of death is not due to suicidal hanging ତେଣୁ ଏଇ circumstance ରେ ତାର ଡେଥ୍ କେମିତି ହେଲା ତାକୁ ସେଠି ମାରିକି ଟଙ୍ଗେଇଲା କିଏ so you have to explain how otherwise the 106 will come 106 of evidence act will come and it will be utilized against you କେତେ ବର୍ଷ ରହିଛନ୍ତି?
He was all along bail during the trial, and so far the conviction is concerned, from the date of conviction he was inside the custody. In one paragraph, it has
Date of conviction is 21/10/24.
And in one paragraph also, one witness has stated that he was not, even the villagers of that rented house also did not support the case.
ସେଗୁଡା ଛାଡି ଦିଅନ୍ତୁ। ଭିଲେଜର୍ସ କହିବେ ଭିଲେଜ ଆପଣ ଘର ଭିତରେ କଣ ହଉଛି ସିଏ କଣ କହିବେ? ଆଉ କିଛି ଦିନ ପରେ ମୁଭ୍ କରନ୍ତୁ।
Even no circumstantial chain has been explained how the death has been taken place. May be taken
pursuant to this an application for bail in view of the evidence of the doctors and circumstances available on record and the surrounding circumstances under which the death has taken place. We are not inclined to release the petitioner on bail. Stands dismissed. Yes.
May it be taken up?
No.
Maybe adjourned to some other day.
Sorry. Yes.
Item 11.
And the time having order dated 4/3/2025 only directed to obtain instruction whether there is any proposal of the state government to file an appeal. I have obtained instruction that there is no proposal.
এটা কিয়ে ফাইল করছি?
The informant.
Informant ro এটা criminal appeal da?
Yes, my lord. Appeal against
acquittal.
Where is the Learned Counsel for the informant? Biswajit Mahanti.
Leave petition हवा कथा।
এটা LRPP ହେବା କଥା। Directly କେମିତି ଆସିଲା ସେ? To be leave of ଇଏ ଦରକାର।
ସେ 372 ରେ ଫାଇଲ କରୁଛନ୍ତି।
ଓହୋ
372 ରେ
direct
ଫାଇଲ।
ତାପରେ ଗୋଟେ ଜଜମେଣ୍ଟ ବି ହେଇଯାଇଥିଲା। ତାପରେ ଗୋଟେ ଜଜମେଣ୍ଟ ବି ହେଇଯାଇଥିଲା ଲିଭ୍ ଫାଇଲ କରିବା।
ନାଇଁ ଲିଭ୍ ରେ ଫାଇଲ ହେଲା ପରେ ତାପରେ ପୁଣି ଏଗେନ୍ ଜଜମେଣ୍ଟ ତାକୁ ଇଏ ହେଲା। ସେ डिवीजन बेंच रहेला 3 जज बेंच कहले ना इन व्यू सेक्शन 372 नो लीव इज नेसेसरी। लीव इज नेसेसरी इन कंप्लेंट केस से जोड़ा का 378(4) रे यूज दरकार से गुडा करे अलगा एटा 372 प्रोवाइड चली असला परे जोड़ा डायरेक्ट समाने ये करिवे जो उठी की अपील लाई करिवो अगेंस्ट कन्विक्शन सेठी ही अगेंस्ट सेठी के हबो एटा जे काउंसिल कहां दी नाहंती। अच्छा खाली एटी के रिकॉर्ड कर दी छाड़ दऊ जो the Learned Counsel for the state on instruction submitted written instruction पाई जाती।
Yes, madam.
दे दियो थोड़ा कॉपी दे दें that the state has no proposal to prefer any appeal against the impugned judgment and order of acquittal passed by the Learned Trial Court. The written instruction is taken on record. Stop. Suffer. Non appears for the appellant. Release this matter. Good date दे दियो। Yes. Next.
Item 12.
I prefer one time.
Mr. Barik, Learned Counsel appearing for the appellant, 6 for an adjournment, date the 2 weeks for it.
Item 13.
On that, one week time you given to file the deposition.
My lord, in this case, my lord directed to issue notice to the informant. Notice already issued and it is served.
The Learned Counsel for the state has produced written instruction received from IIC na card IIC so and so that the notice has been served on the informant. Stop. Non appears for the informant. It was taken on record for the Xerox kari de debe. Learned Counsel for the appellant 6 for an adjournment. कितने सप्ताह दरकार?
1 सप्ताह।
1 week दे दे adjourn कर दे। हेलो? Yes.
Item 14.
Three appeals from order of acquittal in one PS case. Some absconders are there, 3 trials but 1 judgment. Judgment are 3 on a particular date. And on the last occasion on 4/3/2025, my lord directed the state council to take instruction as to whether state has
right, seek some time, my lord.
Torna the instruction Anna.
My lord.
But on the last occasion, I had also pleaded that there are sufficient grounds.
Oh, with that, we have not just let us be confirmed on this. The Land and Council for the state seeks some more time to obtain instruction as per the order dated 4/3/2025. List this matter and we commencing from 5th of May. I mean, master samay dochu, you are getting time. Obtain the instruction. Same order in the connected writ petition, connected criminal appeals, and it is to come along with sworn. 5/5/2025. Yes.
Item 15.
With the council.
My lord, notice sufficient.
अच्छा. Notice माने कौन पे जाइतना?
Victim.
Victim.
अच्छा.
Also.
The Land and Council for the state has produced written instruction received from IICJ police station that the notice has been made sufficient. None appears for the informant. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 46 days since the appellant has been sentenced to life imprisonment.
Yes,
life imprisonment. The delay in filing this jail criminal appeal is condoned. Accordingly, IA is disposed of. JCR the main appeal at the way hard admit call for the trial court report. Yeah. So just soft copy achi trial court record achi paper book
achi paper book achi
admit मांगी तुमती बड़ा सूरी ना
admit ही नहीं
admit ही नहीं चाहिए इतने दास्ची admission पे अब गुरु सूरी ये जो मैं दिल्ली कानून हवा पूरी बड़ा सूरी हाँ तो खाली हार्ड admit कर दें तो हाँ the अपन पेपर बुक पाई चंदी you are Pritam Mahanti.
Yes, ma'am.
पाई चंदा
Yes, ma'am.
admit होला sorry